Many thanks for staying tuned. It's still the conversation here on Lagos Television. Today, we would like to take a look at court judgments and the rule of law. In recent times in Nigeria, we've often been faced with the penchant for not following through court judgments and rulings. In some cases, especially the current situation on ground is what we have in Edo State, where the court asked that all the instruments of office be returned to an impeached deputy governor. And of course, the state governor is still saying he remains impeached. He's not my deputy, despite the fact that there is a court order or ruling in that regard. There is also the principle of the rule of law. Why is it difficult for us as Nigerians to follow through all of the basic principles of the rule of law? Is there a midpoint between court judgment and the rule of law? Hopefully at the end of this conversation, we'll probably find answers to all of these questions. And joining us today is a man of many parts. He's a political scientist, he's a journalist, he's a lawyer, and I'll leave others. But of course, we'll tap into his experience as a lawyer on the program today. Join us as a welcome Barrister Dami Damola. Thank you for being here on the program today.
Good morning. Good morning. Thank you for having me.
Right. Let's start from the basics. And again, let's take a look at the principle of the rule of law. When we say the rule of law, what exactly are we talking about?
Well, thank you. Thank you once again. The rule of law is sacrosanct. You know, the words, like we would say in law, res ipsa loquitur. The fact speaks for itself. The rule by the law. The rule by the dictates of the law, the rule by the dictates of the Constitution, the font et orego, the ground norm. It means that when you say the rule of law, it means the dictate of the law must be adhered to strictly. Strictly. It means you cannot have your emotions dictate what the law says.
Okay.
It means you cannot have your office dictate the direction of the law. It means governance should be in accordance, in tandem to the wordings of the law.
Okay.
It means that those in government must adhere strictly to the law itself. It means that those who are in the position to make the law, Section 4 is clear in the context of those who are in the position to make the law. It means those who are in the position to implement the law. Section 5 is clear about those who are in the position for the implementations of the law. It means Section 6, those who are in the position to interpret the law. That is the basis of Oliver Wendell's interpretation of what the law is.
Okay.
So if we talk about the rule of law, you must not go outside the purview of those who propagated, who pronounced the rule of law in context of A.V. Dicey.
Okay.
That is the rule of law.
Sorry, Ajibola, sorry, just a build up to this. I like the facts that you emphasized strictly. So why is it that sometimes we find it difficult to adhere strictly to what the rule of law has stipulated?
Well, you should also understand that when we talk about the rule of law, we will also now be thinking in context of our sentiment, our position, our status, our political affiliation, our religious affiliation, our ethnic, nationality, and a whole lot of, plethora of issues that comes in that mitigate on personality that wants them to go away from the constitutionality. Because when the law is clear, it means that you must adhere strictly to it, irrespective of the office.
Okay. Irrespective of the office. Ajibola, go ahead.
Okay, I love the fact that you quoted Section 4, 5, 6 when you started your discussion with us this morning, and you said there should be no sentiment. But oftentimes what we have seen in this part of the world is the fact that, okay, we've seen courts, whether state or federal, giving conflicting court orders, and people are blaming the judiciary for some of the crises that we have in Edo State today, that we have in Rivers, and of course that of the Kano Emirship. Is it that our legal officers now, our legal practitioners, do not know the law? And is the rule of law the same thing as equity before the law?
Well, you said it, but there are some that I will be in tandem with, and there are some that I will disagree with you.
Okay.
We are not meant to agree all the time because our personal opinion within the context of your right to Section 39 actually develop our legal jurisprudence. But now let me tell you this. It is not in all cases that you actually have your interpretation of what the law says and you are correct. I am a locus parentis to the Constitution, and in the context of that, within my right of opinion, I will protect my jurisdiction. Now, when you say that...
Is an opinion allowed when it comes to the rule of law?
Yes, definitely. An opinion is allowed, but the opinion, you see, there's something we call obiter dictum. When you say a judge made an obiter dictum, it is the mere opinion of the judge, which is not inculcated in the rule of law itself. It means that even within the purview of your right to your opinion, the rule of law is strict. So whether you have your opinion to an issue, you can render your opinion, you can talk about the way you feel. You see, your opinion could be subjective. And in context of that, we should also understand the fact that when your opinion is subjective, when you are biased in a particular situation, when you have an affiliation based on religiosity or ethnicity, the law itself, Section 1, Subsection 3 of the Constitution, the supremacy of that law must be upheld, and that is all.
Okay, Barrister Dami, let's quickly take a look at only a few weeks ago, the Supreme Court, of course, which is the final court in the land, gave a ruling on local government autonomy, and it is expected that all states within the federal government, within the Federal Republic of Nigeria, should follow suit in that judgment. But here we are, or we had the governor of Oyo State saying that, I mean, that ruling is a federal government ruling, and of course is not binding on state, especially Oyo State. In that situation, would we say that Governor Seyi Makinde has a right to his own personal opinion, or would it also be breaching the judgment of the Supreme Court?
Place Governor Seyi Makinde's pronouncement side by side with the pronouncement of the Supreme Court on the issue of the autonomy of local government, side by side with the decision of the governor of Edo State not to want to abide by
the decision of the High Court.
One thing stands, that even if the governor of Edo State decides not to want to abide by the decision of the court based on the pending appeal,
right,
we will say, oh, an appeal could actually create an avenue for maintaining the status quo, the status quo interbellum. It means every other thing as it is should remain the way it is. Yeah, that could be correct. But see, if there is no appeal to that effect, all that has to do with Section 188 in the context of the means and manner, the directions by which you remove a governor or a deputy governor of a state stands. And Section 35, where the judge in that matter quoted, was perfectly in place. That is the rule of law. Now, until the decision pending is addressed to within the context of the appellate jurisdiction, the matter stays the way it is.
But as it is, from what you've just explained, so if you take the case of Edo State, of course, that judgment was handed down by a high court, a federal high court in Abuja, and of course there is an appeal to that effect. But for Governor Seyi Makinde, that judgment was by a Supreme Court, and I'm not sure that the judgment of the Supreme Court can be appealed.
No, the judgment of the Supreme Court, that is the apex court.
Right.
There is no appellate jurisdiction in context of that. The decision of the Supreme Court is final.
Right.
Like I said, Governor Seyi Makinde's decision and the pronouncement to that context, as far as I'm concerned, is just a mere opinion within the context of his right to hear his opinion. The decision of the Supreme Court in the interpretation of the rule of law, in the interpretation of the Constitution, is final. Original jurisdiction. That's what we call it. Now, in the context of Governor Seyi Makinde not being comfortable with the decision of the Supreme Court, and he has his, constitutional basis for that, he needs to still approach the Supreme Court for an interpretation based on the dictate of the Constitution by which he is speaking from.
Okay.
Because you can't build something on nothing.
Right.
You must build whatever you want to stand on something. And whatever you will build it on must be the Constitution. The 1999 Constitution of the Federal Republic of Nigeria as amended.
Okay, even if Governor Seyi Makinde had said that, okay, the federal government is not superior to the state government, he has a commissioner for justice. Shouldn't he have advised him that, okay, the Supreme Court is the apex court in the Federal Republic of Nigeria, there is nothing we can do, that judgment is final?
You see, one thing stands, and I will continue, it is strike law, that you don't, challenge the decision of the Supreme Court. You cannot challenge. Only the Supreme Court can reinvent itself. Only the Supreme Court can actually re-amend itself. You see, we say that the court makes laws. That is in the words of Oliver Wendell. That the court makes laws. They interpret the law. When they make judgments, their judgment is law and must be followed. You see, there are no ways by which you can actually amend and re-amend their laws. It is final, especially if it is the apex court. Now, in the context of the local government autonomy that we talked about, Section 7 of the Constitution is clear in context of the structure, the modalities for local government, the finances of local government. Now, you can see how governors of the state actually use that as a bait to actually rigmarole the finances of local government and then have total control over it. And then we say that the three tier of government, like we say the three arm of government, the executive, the legislature, and the judiciary. Now the three tier of government, the federal, the state, and the local government. Now the local government seems like non-existing. You understand? And a lot of persons will tell you that it is quite easy for you to walk into a local government. It is much easier, meaning that the local government is
closer to the people.
Now the local government that seemingly, because now it becomes more or less like a scene and a scenario that are closer to the people, now becomes a problem for you to assess such local government because they became more or less a shadow of themselves.
Okay, but
so now you now see that when the fund comes, from the federal government, from the center, which is on its own an aberration, to KC where true federalism. Because when we go by the KC where true federalism, you will see that the postulation of KC where entails the fact that the center must be weak while the component units are strong. So the component units are supposed to be the states.
Right.
Now, the sub-component units are supposed to be the local government. And the local government are supposed to have enough fund for them to do all the necessary, paraphernalia of their office in context of development closer to the people. So now, the Supreme Court has actually made a pronouncement that, okay, fine, local government, you have your full autonomy. Direct funding straight to local government account. Now you can see the governors, they are so quick, they want to quickly conduct
local government
election. Right. Because already on the floor of the House, there is also the debate that, okay, fine, we give local government autonomy. When you give them autonomy, who are going to, is it still the,
state
that will conduct the election? Oh, he who pays the piper, he understand. He understand. So, and then we also understand the issue of the elitists, we understand the godfatherism issue, we understand the party politics. If you don't have an individual, candidacy, it still means that the party decides who run for a particular office. For example, the local government. When the party will decide who runs for the local government, tell me, how do you still expect the local government to be autonomous? It means that the godfather decides who. You see, it is like, the Harold Laswell definition of politics. Politics is who gets what, when, and how. It means the godfather decides, because we practice what? A party politics. The godfather decides who runs for a political party. And when you decide who runs for a political party, you should also understand the fact that there is the Pareto idea in context of the circulation of elite decides that, look, when I run and I become the governor, I decide who runs behind me. Right. Circulation of elite. And that is what we have in Nigeria today. You can see how it revolves around the affluence, the who's, and that is the situation. So it means that in context of that, you don't have the appointment of judges to the Supreme Court, to the Court of Appeal, to the Federal High Court, to the High Court of State, without the postulation, the decision the party understanding of the political party in power of a state. And then you say, oh, all eyes on the, what are the, what eyes are you on the judiciary? What eyes?
All eyes on the judiciary.
What eye?
The
Who
eyes
decides? Who decides?
The eyes will
As a
continue
matter
to
of fact, who decides who become the Chief Justice of Nigeria?
Even senior advocates.
Who decides? You understand? So, look, politics is who gets what, when, and how. It's time we accept the fact that, look, the decision of whatever governance in this country and in other, democratic climb. Look at in the United States of America, the party decides that, look, this man, it seems you are not fit. It's better for you to step down, even though you try to,
to brave it out.
Decide, oh, okay, fine. The party, have it, and that is out. You see, there's nothing you can do about it, and that is the position we have. We better actually accept the fate of the pattern of direction of democracy we practice. That is all.
Are you saying that now we cannot separate the influence of the political parties in power over the influence or the actions of the judiciary?
You're only defining politics.
By who?
You're only defining by Harold Laswell.
Okay, so you're staying with the definition of art. Let's look at the Nigerian definition.
This is the idea. Politics is who gets what, when,
and how.
How.
Right.
Harold Laswell. You can't define politics without defining that. There's no other postulate. There are other definitions.
So is that a universal definition?
Look, see, there is no way you study political science. There is no way you have the understanding of politics. There is no way you practice politics without having the understanding of Harold Laswell's postulation.
Would you then still say that indeed judiciary is the last resort of the common man?
Well, you see, it is said that judiciary is the last hope of the common man.
It is said.
Yes, it is
so.
said. Yes, yeah, it is said that judiciary is the last hope of the common man.
So is it?
Well, like I said, it is said.
So
and
is
I'm going
it?
to repeat it, that it is said that judiciary is the last hope of the common man. But you understand something. The affluence and the elitists in every society control the direction by which politics goes.
Okay.
For example, in Nigeria, like I said earlier, we don't have independent candidacy. And even when you come to have an independent candidacy and it is passed to law, if there's an amendment to our constitution and then it is not solely a party affair anymore, it means an individual can come out and say, look, I'm contesting for Shomolu local government today individually. The question is, where is the capital, the fund coming from? You will now discover the fact that even if he has amassed wealth one way or the other, then the party in power or the government in power wants to investigate the processes and manners at which you have amassed this wealth. Where is that money coming from? We should know. By so doing, you will discover that the person at one time or the other being a permanent secretary, had been a GM, and he had actually embezzled money. There's a problem. It means that the elitists in that society will also decide and determine the pattern of politics you play.
Okay, but people still look up to the judiciary to regulate things. Like I cited the example of Rivers State, conflicting court orders, and of course rulings. Likewise, that of Kano Emirates.
So
the judiciary
you only see politics playing itself out. You see, Kano is very, very
so
important.
the judiciary now and politics are together.
How do you want to? Okay, let me give you a simple analysis. I talked about Section 4, Section 5, and Section 6. Section 4 is the authority to legislative house legislative house that we have it today. That is the House of Rep and then the Senate. Section 5 talks about the power, the authority of the executive, and Section 6 talks about the authority to the judiciary. The judiciary also have a very strong will and what we call the judicial review, and that is what you will see play itself out in some of the decisions, like the decision in Edo State. The judiciary actually reviewing the action of the legislature in actually impeaching the deputy governor within the context of Section 188 and Section 35 of the Constitution. Now look at this. We say that the president, within the context of the executive, will appoint, and then the appointee of the president will be subject to the Senate's approval before you can now become the Chief Justice of
Of
Nigeria.
Nigeria.
You see, the Chief Justice of Nigeria is also the chairman of Legal
Judicial
Practitioner Disciplinary
Council.
Committee.
Okay.
Is also, you see, and then you will now find out that all powers now goes to the Chief Justice of Nigeria in context of anything that has to do
With the judiciary. Right.
It means that Section 4 will only approve whatever is appointed by Section 5
Okay.
for Section
For
6.
So indeed,
Think about that.
indeed,
Just take that home, have the analysis like we did arithmetic.
from that
You
analogy,
understand?
from that analogy you just painted,
Yeah.
it looks like it is not equal after all.
Well, you can equate it within the context of equity. He who comes to equity
Must
comes
come with clean hands.
He who wants equity must do equity.
Right.
You see, it is unfortunate that look, the people that are listening to us at home don't really have a whole lot of persons don't have appropriate grasp at all
of this, right.
They only say all eyes on the judiciary, all eyes on the. Somebody was telling me the other time that look, if there is a Kenya
Uprising in Nigeria.
ideology in Nigeria, you lawyers, we are in trouble. I said, what have we done? We did not do anything new.
You are just part of the
We
system.
are only, looking at what the law says. We look at it, we argue it, my lord. This is what the law says. And within the context of the discretion
Of the
that is
judge.
given to my lord, your honor or your worship, so shall it be, as the court pleases.
As the court pleases is what you said today. But then if we look at what the rule of law has said and the facts that all of this must be strictly adhered to, how can we create a balance in some of these judgments as well as following strictly what the law says?
The rule of law, one of the most important elements of the rule of law, we say is accountability. Another very important aspect of the rule of law is say just laws. We have the laws. Some persons will say, oh, we have the laws, it's just the implementation. Of the law. Some will say, oh, it's just the enforcement of the law. Another very key and most important element as far as I'm concerned is independence of the judiciary.
Right.
Please, with all we have talked about, where is that independence? Where is the independence coming from? Are we talking about independence or dependence? We will not be able to effectively have an independent judiciary within the purview of what we just talked about. It is impossible. When you talk about the appointment of key officers of the judiciary, when you talk about the funding of the judiciary, when you talk about the promotion, the tenure of the judicial officers, look, why are we stressing ourselves? Let's just accept this idea type that we practice,
Right.
and that is the way it's going to be. You see, because if you promote me, for God's sake, my allegiance is
Will
to
be
you.
to you.
Sure.
If you pay me, and you pay me well, if you increase my tenure from 60 years to 70 years, don't you think I'm going to be happy? While I'm even preparing for my retirement. Oh, my retirement is next month. And I'm going to retire, and then I'm planning my retirement. And suddenly, the executive extend my tenure to 70 years. Wow,
So
that is wonderful. It means that I'm still going to serve government for another 70 years. So my allegiance will also
be
be
to the government.
You. He who pays the piper dictates the tune. The executive wields all the power.
Hold the stick.
The executive wields all the powers. The true federalism we are practicing is a strong center. Everybody is running to Abuja. And then a weak component unit. All the states
and the local
begging
government.
Abuja, where the money comes from. And then all the states are also wielding the strong power over
And the local government.
And the local government becomes more or less like a shadow of itself. That's the system we practice.
Okay, will things get better if the judiciary is dependent less on the executive, absolute autonomy now for the judiciary? Will things get better?
If we have a scenario where the appointment of judicial officers is not by the executive, where the appointment of judicial officers is not subject to political party, where the tenure of judicial officers has nothing to do with the legislative house or the executive house, where the funding of the judiciary is absolutely independent. You see, if you don't have a whole lot of facets of, plectoral of issues that cut the executive from going to beg cap in hand, you cannot have an independent judiciary. It is absolutely impossible. You see, the law had actually made it in such a way that, Section 6 is subject to Section 5 and
Section
the confirmation of Section 4.
It's complex.
It is quite complex. It is quite.
So that is the Constitution. And then anything that goes howry of the Constitution, anything that is not in tandem with the dictate of the Constitution, to the effect of its inconsistency, remains what? Null
And void.
Right.
So before we allow you to go
supremacy
this
is
morning,
fine.
so would it also be appropriate, or are you also joining your voice to those who are saying perhaps there needs to be a tinkering with that Constitution?
Well, you see, when you look at the foundation of our laws, you'll also understand that the Clifford Constitution, the
Macpherson
Richard Constitution, the Macpherson Constitution, the Licensing Constitution that erode us into the Ugo Willix Commission of 1958, into our independence, Constitution of 1960, it's all an aberration on its own. The foundation of the Nigerian state itself. It means that if we will have to correct all the plectoral of indices of negativity that becloud the Nigerian state, we need to go to the foundation. And that's the reason why you see, the president of the Federal Republic, His Excellency Bola Ahmed Tinubu, changing the national anthem. We are going back to, and that is it. You see, we need to go back to the foundation. The foundation of that, our diversity, the mistakes of 1914, that marriage of convenience that brought us together. If you had actually traveled wild to Gusau, to Safe, Zamfara, to Meduguri, to Potiskum, you will understand that there are a whole lot of, diversities.
Right.
So why bring us together by force? You see, they're bringing us together by force for us to continually say the one Nigeria. Where is the one Nigeria? We are practicing two different criminal law. The South is practicing this own, different criminal law. The North is practicing, penal code. You understand? Where is that oneness? And you will discover that, okay, let me give you a very vivid example of Deborah, the Samuel Deborah, that was, lynched.
For blasphemy.
Because that is their law. She's a Christian, but within the jurisdiction of what? The penal code. You understand? And then the question is, within that jungle justice meted to her, who has been punished? Nobody. That is the law we practice. That is the Nigeria you call the one Nigeria. That is what I call the mistake of 1914, the amalgamation, the marriage of convenience.
All right, we'll probably have to leave this conversation here this morning. It just feels, or it means like our guest has said today, we need to go back to the basics. But who will build the carts? That remains the biggest challenge as I speak. Thank you so much, Damola Kolawole, for coming on the program today. We appreciate your thoughts.
Thank you for
We'll take a quick break. The conversation returns, and when we come back, the ladies will take it away from us.